I did want to ask you about writ petitions. A common question that appellate attorneys ask is what type of criteria appellate justices are using when deciding to grant writ relief. And I wonder if you could share any best practice tips with our audience regarding writ practice.
Well, I think the primary thing that gets looked at first is it going to matter if we grant or deny the writ? Because if the course of the case is really not going to change, it's extremely unlikely that a writ's going to be granted. I think that's worthwhile to keep in mind that, I know the sting of a loss as well as anyone who's ever gotten a case ready and taken it in the trial court, but sometimes it's really not going to matter. On the other hand, if you have an issue that is going to be dispositive of the case, and if the decision goes the other way, the case will have to be retried. That's a very good case for a writ. Because the court does understand that the last thing you want to have happen is have a case get fully tried and then retried when you could have predicted from the get-go that was a likely outcome.
That is good. I have seen those issues come up before. I also wondered about, there are probably a lot of writ petitions that get filed by attorneys who don't file a lot of writs and maybe don't understand the rules, don't understand the criteria for getting a writ, and maybe those are easy calls to summarily deny them. But there are a lot, I would guess, that were filed by attorneys like myself who think this is really a righteous writ. This really ought to really deserve some consideration on the merits, and it gets summarily denied as well. And I wondered if there is a common thread that goes through these kind of almost writ petitions, or are there just a lot of hard, tough calls that have to be made?
It's really just a lot of hard, tough calls. And some of it is trying to figure out whether it is going to matter in the case or not in the long run, or whether this is an issue that's going to work itself out later in the case without intervention. But, you make an interesting point. Sometimes lawyers who file writ petitions who are not accustomed to them, those writ petitions may get more attention because if the panel doesn't want to make a mistake, and I can't think of any panel that wants to make a mistake, they're going to look and see if there's anything there that is lost in the fact that it isn't well presented. So I would urge your listeners to do the very best job you can on a writ petition and tell the court, number one, what's wrong, and number two, why it matters. But also to rest assured that I can't think of a panel that doesn't pay attention even to a writ petition that isn't well prepared.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.